Here's an argument you often hear in the Second Amendment space, including in the comments of this very channel. The argument goes something like this: the only firearms that the founding fathers of this great country understood or knew about were single-shot muskets. So there's no way that the Second Amendment's right to keep and bear arms was supposed to or should protect the dangerous modern weapons we have today in 21st century America. But when we get back, I'm going to teach you all how to debunk this argument once and for all. Hey folks, I'm Mark, and welcome to the Four Boxes Diner. Anti-gunners like to argue that the founding fathers who wrote the Second Amendment never envisioned things like modern so-called assault weapons like AR-15s, and therefore those types of firearms are not protected by the text of the Second Amendment. Now here's an easy and quick response I want to help you out with when you hear this argument. The answer is, so what that the founding fathers did not specifically envision an AR-15 when they wrote the Second Amendment? It's really that simple. And if you think it sounds like a weak schoolyard taunt or comeback, here's what I mean by the argument. You see, your liberties are in deep, deep trouble if you expect that the Bill of Rights to cover only those technological advances that our founders specifically envisioned and understood to exist some 200 plus years ago. The founders did not foresee things like the telegraph or the telephone, let alone social media or the internet. But does this mean that the First Amendment should cover only pamphlets and not YouTube videos and blog posts? Of course not. Or how about the Fourth Amendment? Now, the Fourth Amendment is the amendment that protects you from unreasonable searches and seizures by government. Now, the amendment mentions that people should be secure in their papers, the papers. But does the fact that it says papers in the Fourth Amendment mean that you're out of luck if the government comes to review your emails or text messages? No, not at all. You see, the Constitution isn't about things or about particular technologies. What the Constitution is about, including the Second Amendment, it's about our freedoms, our rights as American citizens. And that's why the First Amendment applies equally to all forms of media, whether it be the internet, television, newspapers, and all the rest. And that's also why the Second Amendment applies equally to all modern firearms that are commonly used by law-abiding Americans for lawful purposes such as hunting, self-defense, and target shooting. And I've got some more good news for you folks. You see, you don't need to rely entirely on Mark's so what argument. That's because it's not factually accurate or true to say that the founders of our Constitution, the people that wrote the Second Amendment, were only familiar with things like single-shot muskets and dueling pistols. Nope. Not true. There were plenty of other sophisticated firearms that were available and understood to exist during America's founding period, which again, the Supreme Court says is the period you look at to understand what the Constitution means, including the Second Amendment. Take, for example, the Austrian rifle, the Girandoni air rifle. This was in the United States, okay? The Girandoni air rifle. This gun was invented more than 1 decade before the Second Amendment was ratified. It had a magazine that carried, ready for this folks, more than 20 rounds of ammunition. Yep, you heard that right. The Girandoni rifle carried more than 20 rounds of ammunition. Now compare that with today's anti-gun lobby, which wants a federal ban on magazines, so-called high-capacity magazines that hold more than 10 rounds. But remember, the Girandoni rifle was used by Lewis and Clark in the early 19th century, right smack dab in the middle of the founding period. And why do we say this? You see, Lewis and Clark was set out west with, among other things, the Girandoni rifle with 20 rounds in a magazine to explore what the United States had purchased with President Thomas Jefferson from Napoleon Bonaparte, the head of France, right? We'd bought the Louisiana Purchase from France, and Lewis and Clark were sent out to explore that territory carrying a 20-round Girandoni air rifle, okay? And when they brought that air rifle with them, with 20 rounds in it, in the early 1800s, guess what? They put on shooting expeditions and demonstrations to wow the native tribes that they encountered on their big trip across America. And there were, of course, in addition to the Girandoni rifle, there were other multi-shot and multi-barreled guns that existed at the time as well. The way I kind of like to think about it in terms of a modern day analogy is that some of these guns were known to exist, but they were still very expensive. They're a little bit like maybe a Tesla electric car today. They're not ubiquitous. They're not everywhere today because they're quite expensive for most Americans. But the technology does exist, and it's well known, and people understood this. And again, the same way with some of that firearms technology that existed in the 18th century, it may not have been everywhere, but it was known to exist to our founding fathers at the time they wrote the Second Amendment and during that founding period, which again the Supreme Court says you have to look at in understanding the meaning of the Second Amendment's text. Here's the third reason why it's absurd to say that the founders were not thinking beyond simple muskets when they drafted the Second Amendment. You see, the Constitution, that's our Constitution, the exact same Constitution, by the way, that includes the Second Amendment, okay? Our Constitution provides proof positive that our founders definitely understood the value of technology and how they encouraged the development of all forms of technology, including those touching on firearms. All you need to do, folks, is Google, right? Check out the internet or pick up your copy of the Constitution itself and take a look at Article 1, Section 8, Clause 8 of the United States Constitution. And what do you read when you look at that? That clause gives Congress the power to grant patents and copyrights to promote the progress of science and useful arts. You see, firearms were definitely included in the technology that the founders wanted to improve as a matter of national security. Remember, during the American Revolution, the founders were intimately involved with securing arms and powder to make them work. Early in the American Revolution, we obtained muskets and other weapons from, for example, France. After all, French gunpowder gave Americans a great advantage over the mighty British Army. And why is that? It's because that gunpowder allowed the Americans to shoot farther than the British. The founders also ramped up the domestic production of firearms, and by the end of the American Revolution, they had even developed forms of hand grenades. Now, after the American Revolution, the founders kept at it. In 1795, Thomas Jefferson wrote from France, because that's where he was visiting, that's where he was working at the time, to alert his American countrymen of a technological breakthrough that he was shocked by and thrilled by. You see, Jefferson had discovered a gunsmith who was making arms with interchangeable parts. This was a big deal, right? Now, Jefferson, you see, was an inventor and an innovator, in addition to being the author of the Declaration of Independence. So when Jefferson saw a breakthrough, he knew it. He knew a breakthrough when he saw one. And 3 years later, guess what happened? Congress awarded large contracts to build out America's store of weapons. You see, the biggest contract of them all went to Eli Whitney, who is famous for being the inventor of the cotton gin. But Whitney also promised to use interchangeable parts to make gun manufacturing and repairs much more efficient than it ever had been before. The founders understood that firearms technology was advancing rapidly, and they wanted to be sure that Americans had access to the best and latest innovations, and that made a lot of sense. In the landmark 2008 Heller decision, the United States Supreme Court flatly rejected the idea that the Second Amendment protects only those firearms in existence at the time of our founding. And in a later case in 2016, a case called Caetano versus Massachusetts, the United States Supreme Court really showed that it meant what it said in Heller about this firearms technology argument by the anti-gun community. You see, in Caetano, the Supreme Court of Massachusetts, the Massachusetts Supreme Court, upheld a ban on stun guns, and they did so in part because they obviously were not the type of weapon contemplated by Congress in 1789 as being protected by the Second Amendment. The United States Supreme Court disagreed, explaining that, quote, it is inconsistent with Heller's clear statement that the Second Amendment extends to arms that were not in existence at the time of the founding. And that Supreme Court vacated the Massachusetts Supreme Court's ruling because the Massachusetts Supreme Court got it wrong. And a couple years later, the Massachusetts court clearly showed it got the message when it said this in a later case. In that case, the Supreme Court of Massachusetts applied the Heller test, and it declared that, quote, stun guns are arms within the protection of the Second Amendment, and therefore they could not be absolutely banned under the Constitution. Okay. Now, here's the thing. If stun guns are protected arms under the Second Amendment, it must also be true that other modern arms, like AR-15 platform guns, which are owned by many, many more millions of people than own stun guns. So again, if stun guns are protected under the Second Amendment as modern arms, so would AR-15s. And I think that's what the Supreme Court will ultimately say when they eventually get to dealing with the so-called assault weapon ban. So let's wrap up. The next time someone argues that the Second Amendment does not protect modern weapons because the founders did not envision anything more than single-shot muskets or dueling pistols, here's what you need to say. Number one, the Bill of Rights, including the Second Amendment, protects freedoms, not particular technologies. So it really doesn't matter legally whether the founders anticipated certain firearms technologies 200 years into the future. Remember, the founders did not anticipate the internet or smartphones either, but the First Amendment still protects your free speech rights on those platforms. Number two, the founders of the Constitution, including the Second Amendment, knew about sophisticated weapons beyond muskets at the time. Okay? During the founding period, there were multi-barreled guns, and there were guns with magazines that could hold 20 rounds of ammunition, such as the Girandoni air rifle that Lewis and Clark used to go across the country in the early 19th century. And number three, the founders cared a lot about technological innovation. Many of them, such as Benjamin Franklin and Thomas Jefferson themselves, were innovators and inventors. And the founders, of course, sought cutting-edge technology when it came to firearms because it was important for national security. In fact, the Constitution itself, just take a look at it, encourages and protects new technology in the copyright and the patent clause. Just take a look at Article 1 of the Constitution and you'll see that the same men that wrote the Second Amendment put in Article 1 including the concept of copyrights and patents for protecting new technologies. So to suggest that the Founding Fathers did not anticipate improvements of weapon technology and firearms is simply absurd and inconsistent with the text of the Constitution itself. Okay, well, I hope you learned something today about our founding period. And again, thanks for joining me here at the Four Boxes Diner, where we serve fresh, hot Second Amendment news and analysis. And if you like what you heard, I'd appreciate if you could subscribe and help us spread the word. And we'll see you soon again here at the Four Boxes Diner.
Orders up. Table 2A.